Good evening. Today we're going to discuss about can I apply for H1B lottery for 10 different employers at the same time. We're going to also discuss about the interfiling updates of the I-485J where people were trying to move from EB3 back to EB2. We're going to also discuss about the freedom of information, how you can benefit it, when you should file it, what are the advantages sometimes of using the Freedom of Information Act. Emily, why can't I file from 10 different companies? It's only $10. The employers are not even asking any money.
Yeah, the problem is you don't know how many other people these companies are making the same offer to. And it may be hundreds of people when those companies don't actually have a job available for you. I mean, that's misrepresentation or fraud. And you might end up getting selected with that company. You might file the petition and get the approval with that company.
So, isn't that it, what I want?
You would think. But we're here to tell you every day we get consultations, emergency consultations from people who went through this process, ended up with a fraudulent company, got their H-1B selected, got it filed, got it approved, transferred to another company, extended with another company. 3 years later, now they are getting revocations. They're getting banned due to inadmissibility.
You're speaking of internal project filings for the consulting companies which didn't have it.
Right.
But I haven't seen anything where they have yet to issue any of those things right now for the multiple filing. I mean, one company filing for hundreds of people. Why can't they take action right now?
I think part of it is they're trying to get the bigger fish and as many people as possible. So if they keep approving them and it keeps working, more people will do it. And then 3 years later, 6 years later, that's when they go after these people. And they go after the person who got the approval notice from that company by saying, hey, that was fraudulent. That means it's revoked ab initio. That means from the beginning. They treat it as if that application never existed. Well, guess what? If your CAP case never existed, you've never been counted in the CAP. You might get your extension 3 years, 6 years later denied because you were never counted in the CAP because of your initial registration with one of these companies.
Emily, I spoke with a lot of lawyers. They're very clear, the law is very clear that you can file for multiple companies at the same time. Why are you the other way around?
Yeah, the issue is not with filing with multiple companies at the same time. The issue is the company, which companies you're choosing to do this. Now, if you came to me and said you had a job offer from Google, Apple, Facebook, or Meta, and I don't know, eBay or Amazon, I'm going to say I'm okay with that. You can do those registrations because I know those are good companies. But if you come to me and say you've got all these 5 different companies or 10 different companies and you heard of them from a friend and you don't know anything about them, you've never talked to them, they're saying that they'll find a project for you later if you get selected and they're going to help you out. And they also have a sister company who can do the same thing for you. That is going to be a problem for you. So please, we advise you to stay away from things like that.
My friend filed for 5 different companies last year. He got selected with 2 companies. He got the approval. No problem. What's your problem, Emily?
Yet. It's coming. We get these consultations all the time from people 3, 4, 5, 6 years ago that did this at that time. And now they're getting revocations. Now they're getting their denial. Now they're getting their visa denied at the consulate due to fraud. And that puts a permanent ban. You can't come back.
I see advertisements in the Indian, we have our own circles where the companies are advertising that, hey, we are going to file for multiple H1Bs with sister companies. Come and join us. Why can't, when they're advertising that, isn't that legal?
No, that's the interesting thing is USCIS is actually changing the registration language this year. And it says you are prohibited as an employer, when you submit your registration, you're submitting it, the employer, under penalty of perjury, saying you've not colluded with other companies to submit multiple registrations. That's new in this year's lottery.
But that's the employer's problem, Emily, not my problem. Why can't I apply?
Well, I mean, when that employer gets caught, everything that employer filed is going to be revoked. That's your petition that's going to end up revoked.
We have seen this very many times, guys. There are companies that have offered the OPT and STEM extension like Integra, Aztec, and Will companies. These companies offered like thousands and thousands of people. They gave the letters, and now most of them are being thrown out of the country. We've been denied. We've been hit with fraudulent misrepresentation. They can never ever come into United States. What happens is that if your H1B gets selected with this fraudulent company and then they file the H1B, you may get this temporary benefit though. But at a later time, you will be barred you'll be barred forever. This guy who made money on you will be probably sitting in a beach in Goa and might be enjoying with your money, but you will be the ultimate sufferer though. So we advise people to stay away from these companies. Don't go with these companies. And if you find any of these companies though, there is a fraud detection unit of the USCIS. Report to them. In fact, there is a lawsuit filed against USCIS not taking action in it. They have pointed in that lawsuit that was being brought by the people who did not get selected. They pointed out multiple instances where these consulting companies have filed fraudulent applications. They have advertised so many of those things, and it's been presented in the lawsuit that these are the companies that are doing it. Yes, you still have an option. If somebody is doing that work though, we strongly recommend that you complain to the USCIS. This particular company, without a job offer, they are making it. Make a very detailed complaint. The USCIS will take action on it. We should try to prevent. Now, if you are part of the fraud though, you will be hit with misrepresentation. You'll never be able to come back into the United States. Another thing is that even if you don't know these things though, even if the company does anything fraud, as Emily has pointed out, you will be technically counted as if that you have never been got the H1B selected to the lottery. You will be out of the lottery. Even though you move out of this company to company B and company C, you will still be in trouble. Your company C's H1B, even though company C might be a Microsoft and doing very good, they will revoke the Microsoft H1B because your first H1B is fraud. So be careful, be wary of these companies, and if you have any of these companies, report to the USCIS fraud detection. They are going to take action on those things. Anything else, Emily?
No, I think that sums it up. So we also have interfiling. That was a new process when USCIS came out with an alert saying, we have tons of green cards available in EB2, please come back to EB2. And they set up a special filing location and gave us instructions for how to do the interfiling, which we never had before. Are you seeing any results from that? Have you filed any of those?
Yes. From the last week of January to right now, we've been still filing the I-485J supplement. And Emily, here is the thing. Not a single case that we have filed for the 485J supplement have ever received the receipt notice. Not a single case ever been approved under EB2, even though we requested. Now, I don't know whether it's a short term. It's almost a month right now that we haven't received any approvals. So I'm seeing adjudication outside these interfilings, but not within these interfilings though. Maybe things will change. We'll keep updating every week, but at this point of time, we have not received the receipt notices for the 485J supplement, which we should have been. We have not got any of the approvals of the 485J supplement, but we'll keep updating on this. Please keep watching our channel every week so that we keep bringing this news, because the things change frequently. So these kind of things, 485J supplement, sometimes all of a sudden we get all the receipt notices, we may get the approvals. So things change, and we keep updating the update on when the 485s are getting approved, which center it is getting approved on the immigrationgirl.com, which Emily manages it. So keep watching the immigrationgirl.com and her blog. She updates it, the number of green cards from one particular lawyer's table in this in our office, how many of them are getting approved, and we keep updating that in the immigrationgirl.com. But as of now, 485J supplement, we have not received it. We have not received any approvals for the interfiling from EB3 to EB2. Anything else, Emily? All
right. Next up, Freedom of Information Act. What is it? What benefit does it have to you? Can you explain exactly what you do with Freedom of Information Act?
Normally for our clients, for the business immigration clients, Emily, the company is not giving the I-140 approval. That is the number one cause. What people complain. You don't have to do anything. You just go to the Freedom of Information Act, FOIA, USCIS, hit that in the Google, and Google will find it for you. You fill it out for 10 minutes, 15 minutes. It's free, it's online. Even though they say they're going to charge extra money if they print, if they do something, but believe us, we have never been charged extra. Even if it is, it's going to be very less money. You don't have to worry that much, especially if you are on a business immigration visa. You can afford that $15, $20, I guess, for sure. Please file that if your company is not giving you the I-140 approval. Even if the company is giving you the I-140 approval, you need to know what's in there. File a freedom of information. Even though you don't actually get the approval notice when you file the freedom of information, but it has everything in it. It has the I-140 receipt notice. It has the labor certification. It has your I-140 file. It has all the details. That is more than enough for you to have with you for any reason, for extending the H-1B, for filing the EID extension, other things. That's one reason. The other thing, Emily, is that nowadays 485, I mean, it's with the Texas Service Center, it's a black hole. Sometimes people have sent interfilings of the medicals, sometimes the biometric notices. So I'm telling people, if Emma is sometimes gives good information, but it doesn't give full information. I'm telling people, if you are 485 pending, go and file the Freedom of Information Act. Just file the application. It takes some time for them to respond. You may get to see what they are doing on your 485 file. That's one. These are the two common things. Now, other than these things, so sometimes when there is any criminal record that we don't know about the individual, we are not clear whether there is any particular information about this particular guy in the 485 I-140. I tell people to file the Freedom of Information to see what information is there in the files of the USCIS. Sometimes they give all the information, sometimes they withhold the information. That means that there may be some trouble on it. I can interview the employee more detail to find out if there is anything that we need to know, because when we are representing the client, I would like to know all the information, what the client has it, what the immigration has it before I go. These are the most two common things. One is I-140, one is 485 that I try to get it.
And the process is simple. I mean, like you said, if you just Google USCIS FOIA, it'll take you to the website. You do it through the My USCIS account, just fill out some basic information, and you usually receive that information electronically because they do have most of these things scanned. So it just takes a few weeks.
Yeah, and then try to use liberally. If you file for an I-140 information, your employer will not come to know that your you filed the Freedom of Information. Nobody will come to know. It is between you and the immigration, and they will send that information to you in email. So that's easier for you to get that information. I mean, not much paperwork is required. Typically, it may take anywhere between 3 weeks to about 7 to 8 weeks for you to receive it.
All right, going to questions. This is from Kavya, wants to know, how long can we stay outside the US while an AOS is pending? I think you're limited based on your advanced parole validity period, because you can only renew an advanced parole if you're in the US. So you have to return before your advanced parole expires. Or if you are using H or L status, you have to be in H or L status when you leave and come back in H or L status. So if that's expiring, that can be a problem as well.
Harry Caps has this question. Is it possible to travel and return to USA while I-130 and 485 is pending, marriage-based US citizenship marriage? Assuming your advance parole is not approved, if you are on H1 or L1 and if you're traveling, that should be fine. If you have any other visa other than H1 or L1, you're planning to travel while the I-130 and 485 is pending and your advance parole is not approved, you would be considered to have abandoned your 485 application. So you better check with a lawyer before you leave if you're not on L1 or H1B.
Kamal has the H1, H4, and H4 EAD filed concurrently. H1 is already approved thanks to premium processing. Spouse then went to get the H4 stamping by visiting India and wants to know, how do I provide the new H4 I-94 to USCIS for that H4 EAD? So this is another situation where interfiling is what you would do, and that's simply sending a letter to the service center where the application is pending. I would do this for both the H4 and the EAD, along with a copy of your I-94, and asking them to interfile and put that into the file so that your H4 and EAD can be adjudicated based on this new I-94.
RK has this question, when to upgrade H1B Premium Processing? Well, he wants to know if the H4 and EAD will be approved along with the H1B. No, they are not getting adjudicated along with the H1B. H4 and H4 EAD are not getting adjudicated. Previous to 2019, they used to, but from 2019 onwards, when they introduced the biometrics, they stopped adjudicating H4 and EAD together. Even though biometrics are not there right now, they're still not adjudicated. Now, there are some 1 or 2 cases that are getting adjudicated along with the H1B, but by far, most of them are not getting approved. So it doesn't matter when you upgrade to premium processing. Most probably, you have to look into the alternative sources of getting the H4 plus EAD approval. There is a video that we posted about H4 180 days. Search it in the H4 180 days in the YouTube, and you will find out that 10-minute video. I want you to watch that video.
Surrender working full-time in location A and planning to move to location B to work remotely where the company doesn't have an office, and wants to know, can the employer file the green card application from location B? So if this is becoming a telecommuting type of job where you could basically live anywhere and still work for that company, the Department of Labor has specific guidance for telecommuting jobs, and they say that the recruitment, the test of the labor market for the labor certification process still is to be done at the company headquarters, not at your work location. So they should definitely check with their immigration attorney to make sure the attorney is aware whether this is going to be falling under the telecommuting policy and can be filed based on the company headquarters.
Rupesh, can I enter US via an approved I-140? Approved I-140 is not a ticket for you to come into United States. You must have a non-immigrant visa to come into United States. It could be H1, it could be L1, H4, L2. These are the things that you can come on. Just because you have an I-140 approval, you cannot enter into United States.
Sudhakar says, what happens if the interfile request fails? Will they cancel the whole 485? Do we need to file it again? So the interfile request failing, that basically means USCIS is using their discretion to say, we're not going to transfer this case from EB3 to EB2 because it's not convenient for them, or it would take longer, or whatever their reason is. It doesn't do anything to the pending case related to EB3, assuming this is an EB3, EB2 type of situation. So it doesn't do anything to the pending 485. They just won't be adjudicating it pursuant to your EB2 approval.
Anita Kapp has this question. Priority date is April 2016. When will it become current? That's $1 million question though. It depends on how many 485 applications they would adjudicate this year though. They have 280,000. If they adjudicate all of them though, there is a chance next year, that means starting from October, the date can move beyond January 1st of 2015. But if they don't adjudicate these applications though, it could take maybe 20 years for you to get the priority date current. So it could be 1 year, it could be 20 years, depends on how many adjudications they do. So Anita, my request to you is that we put 2 letters. One letter is for the USCIS to adjudicate the applications faster. The second letter we requested is that while the Congress is not doing anything from past 20 years and not expected to do anything on immigration for the next 20 years, the administration can act and make some changes so that your priority date of April 2016 can be current. That is, if they stop counting the family members, they have a discretion, because when the USCIS, when the Congress has passed the legislation, they didn't set to count the family members. They didn't set not to count the family members either though, but they started counting the family members. If the administration right now wants to make, hey, we're not going to count the family members, they can not count. If they do that, then the number of green cards will go from 140,000 to about 320,000 green cards. So that'll be enough for you to get the priority date to be current immediately if they start doing it. So these are the 2 things that we have put links there. We want you to contact the USCIS to stop counting the family members and also stop adjudicate the entire 280,000 applications. If any of you guys are waiting for the green card, waiting for the priority date to be current, please write these 2 letters that we have given the link. This is the best thing that you can do right now.
Aquila says, for the GCEB2 process, what happens if the team or job description changes while the recruitment is in progress? Do we need to start again with a new prevailing wage? So the team should not matter because that's not something that's relevant in the prevailing wage and in the recruitment process, but the job description is. So what you have to submit to DOL is the basis of the job that you're being sponsored for. That's job title, job salary, work location, job duties, an education requirement, and any special skills and experience requirement. If any of that changes in a material way, a substantial way, then that company is no longer recruiting for the correct job and they would have to start over. So it really depends on what's being changed and how much of a change it is.
Sachin has this question. Do I need to have an I-140 approved for interfiling from EB3 to EB2? Can I interfile outside USA if traveling? First question is, you can file interfile even if the EB2 I-140 is not approved. But I don't see a reason why you're interfiling. When you're interfiling, you are telling USCIS, please give me the green card. But now, when you're interfiling, your EB2 is not approved. How can they give the green card? They can't give the green card. So you have to have both I-140s approved though. That's my recommendation to do it. Can you do interfile outside of USA if you're traveling? Absolutely you can. No problem with it.
USCIS, says my priority date is current, biometrics are done, 485 is filed, H1 is expiring in October, and visa stamping is not done yet. Is it safe to travel to India now? Well, the fact that the H1 is expiring in October isn't that big of an issue. The fact that your 485 is pending, as long as you have H1 status at the time you leave and you're coming back in H1 status, you don't need an advanced parole to come back. But the issue is the stamping. So if you are called in for an interview for your stamping, you could get stuck with administrative processing. Or if you even are eligible for the drop box, they may still have you come in for an interview. So it really depends on the type of company you're working for. Do you have anything in your history, immigration history, any issues that might come up during that visa stamping that could cause what we call administrative processing, which can be a major delay of weeks to months, and you could end up stuck outside the US till October with no petition to come back on.
Hillary D'Souza from YouTube has this question. Are you seeing any approvals of the people who have filed 485 application on October, November in Nebraska Service Center? Yes, we do see that. And I want you to, anybody who's wanting to see what is the trend of the approval though, the best article that is ever published is an Immigration Girl blog, which Emily manages, and we keep updating every week. So please watch that blog. It tells you when it has been filed, what service center is it, what's the priority date, when it got approved, all the details are there and gives a very clear signal. Of course, we all know that the worst service center is definitely Texas Service Center. And comes close next is Nebraska Service Center. And the best is, of course, National Benefit Center, which also starts with MSC. We all know that, but I'm just letting everybody know again.
Anshuman says, is the new L2 rule to work without an EAD in effect, and can I get it done without traveling if my I-94 is extended already? So yes, the rule is in effect. USCIS has started issuing L2 extension approvals with the L2S notation for spouses, and CBP has been issuing those I-94s when you're traveling. For those that are already here and don't have that I-129, or I'm sorry, the L2S notation, it's slightly unclear. There was an update from CBP that was shared with American Immigration Lawyers Association where they kind of suggested that you don't have to have that notation, the S on your I-94, as long as you are actually an L2 spouse. They said they were going to be updating the I-9 guidance and the policy manual. I haven't actually seen those updates yet. So it's really going to be whether your employer will accept that I-94 that doesn't have the S notation based on what CBP has come out with so far.
Prashanti has this question that after AOS biometric got updated portal, they got updated in the portal, but the 13-year-old kid did not get any update in there. First of all, Prashanti, I don't think so. 13-year-old guy, 13-year-old guy biometrics have been taken though. He typically we don't pay the fees for 13-year-old people biometrics though. But even if they have taken the biometrics, they may not update it because biometrics are only for the people who are under above 14 years. This is only I'm speaking about 485 application guys, not other things. So under 13, that's fine. I mean, if it's not updated, you're good. No problem with it.
Madhur says, my H4 EAD expired in January and I switched jobs in February. Can I work for the new employer? I am eligible for the auto extension of the 180 days. So that means that you have already received an extended H4 I-94 and you already filed your I-765 for the H4 EAD renewal before the current one expired. So in that case, you would be eligible for the automatic extension. And yes, it works with any employer. It doesn't have to be with the employer that you were working for at the time your EAD expired.
Harsha Ranjit has this question. What are my chances of OPT approval if I have the I-130 pending? We have seen this many times where the I-130, the immigrant petition is pending and people are on F1 visa, they filed OPT. We have not seen any problem in OPT approval, honestly. Technically, there may be some issues, but we haven't seen any RFEs or denials. We've only seen approvals, Harsha.
Momo says, for physical therapists who do home health, does the LCA need to be filed for every county they work at? My company's office is located in 2 counties and the main office location does not change. That's how I handle these cases. I do list every county that you may work in as a potential work site at patient's home. So I do sometimes have multiple LCAs to get all of the counties in there.
But Emily, what if I'm working at the home health doesn't list a site?
Mm-hmm.
So for example, I may be visiting one client, another client, another client. It's not going to be the same patient. Is that okay?
I say work at patient home in county X.
Oh, okay.
Mm-hmm. So it covers the whole county.
And if they don't do it, they should amend the H1B right now.
Mm-hmm.
Okay. Just want to know, sometimes I'm not aware of it.
Ashatush says, question regarding automatic revalidation. Can I travel to Canada and come back with an approved H1B 797 but an expired H4 visa? Never got the stamping done. Yes, assuming your H1B was a change of status and you have the I-94 attached to it, automatic revalidation does work to revive an old visa even if it was in a different status for the purpose of entering at that moment.
Moshin Khan from Facebook has this question. H1B expires in August, applied for renewal along with H4 plus EAD in premium processing, I'm assuming. I-140 is already approved. What's the best strategy to avoid the employment gap for the H4 EAD? The best thing is get the H1B approved. Of course, you file the H4 plus EAD. Once the H1B is approved, have the H4 applicant travel to Mexico, come back and show the spouse's H1B approval, get the I-94 until the expiration of the spouse's H1B approval. Then, since this person's H4 EAD is expiring in August though, they will have a valid I-94 until hopefully 2025. They can continue working for a period of 180 days after August of 2022. So that will lead all 180 days all the way to January of 2023. They can work, and hopefully by the time the EAD approval comes in. This has been explored very much and we tried it on many different people and it works very good. There is a video we presented on it. You can search it in the YouTube, H4 180 days extension, Reddy Neumann PC. You will get that. It's a very good video that you and your spouse should watch.
Praneeth says, can I do an H1B transfer with any approved I-140 from a previous employer or only with the latest I-140 from my current employer? You can use a prior employer's approved I-140 as long as your final action date is not current and that I-140 was approved for at least 180 days before it was withdrawn, if it was withdrawn.
My husband, Sukanya Singh from Facebook, has this question. My husband filed for 8 fine 2020, downgraded EB3. It's been 2 years, there's nothing, my husband wants to change the job. Can he do that? Sukanya, first thing that I want to know is that did the I-140 for the downgrade approved or not? If the downgrade of I-140 is approved, yes, he can change the job. If the EAD is not approved, he can still file the H-1B and change the job. If the I-140 is not approved, it's still pending, I strongly recommend he does not change the job. He wait until the I-140 is approved, and there is a premium processing. You should try that to get the I-140 approved faster.
Aria says, my manager left the company and I moved to another group, but my job description is the same. Do I need to update anything on my H1B or green card application? Generally, no. If the job is the same in terms of job title, salary, work location, duties, education, and experience requirements, then nothing really has changed. The H1B petition or the green card process has nothing to do with who your manager is or what team you're reporting to.
Sumit Kumar has this question. It's an interesting question. Is there any route cannot be traveled from India to USA? It's a quiz question which the other people are asking. The question is, Sumit is saying that H1B or H4 visas. One thing we notice is that there are some consulates, some port of entries that are not good. One of the port of entry we don't like the most is Chicago. The second one is the Abu Dhabi port of entry. We try to avoid these two things. They ask unnecessary questions and they sometimes put good people into trouble. That's the only thing that I can think about.
Karthik says, my PWD was submitted in July 2021 and the employer says they're still waiting for the outcome, but the processing time in the DOL website is August 2021. Is this website correct or not? Yeah, they are normally taking about 6 months, so it seems like you should have gotten it by now. So that DOL website has been pretty accurate. If you have the case number for your prevailing wage in the flag system, you are actually able to put in that case number and it'll tell you what the current status is in the flag website. Not logging into the system, but you do need to have the case number for your prevailing wage request.
Roni has this question. I am in India. My H4 visa is valid until March 23rd, 2022, which is just a month from now. Can I travel to USA? Yeah, absolutely, no problem, Ronnie. When they ask you why are you coming only short, you can explain that if your spouse already have the one thing, if your spouse H1 is already extended though, I would recommend that you carry the H1B approval of your spouse and show it at the port of entry. They may give an I-94 until your expiration of your spouse, but at least under any circumstances, so they will not deny your entry. You can definitely come back even though your visa is only valid for only 1 month period.
Sukanya says, my husband filed,
I answered
you got that
question.
one? Sorry, I'm behind.
Dheeraj Prasad from YouTube has this question. Can I use the advance parole if my EB3 I-140 is still pending? We strongly recommend not to use the EAD and advance parole unless the I-140 is approved. However, though, if you really want to use it, you can have a consultation with a lawyer, go through to see what are the prospects of your I-140 approval, what are the chances that the I-140 could be denied, because that will be the major cause for me, because if the I-140 gets denied, everything falls down. So once the I-140 is approved, 485 denial chances are very less. So that's what I'm a little bit worried about it. Check with your lawyer to make sure. Don't check with your current lawyer though, because your current lawyer may have confidential information, but he may not release that information to you because of the conflict of interest he may have with the company. But if you check with an independent lawyer, it may be better for you to evaluate if your I-140 is approvable or not.
Vicky says, my spouse who had the biometrics taken a month after me received her EAD and AP combo card yesterday, but mine is still not showing any progress at the Texas Service Center. What can be done? At this point, if it's been pending for 6 months and still no action on it, we are filing lawsuits and we are seeing success with that in getting the EAD and AP cards issued. So if that's something that you would be interested in, we would recommend contacting Stephen Brown in our office at stephen@rnlawgroup.com.
For any unusual delays that are happening with the I-140s, 485s, EADs, we strongly recommend to contact Stephen Brown in our office, guys.
Gory Sinker says, I'm an H-1B, I-140 approved since the last 5 years. Can I go back outside the U.S. and come back with an L1A to upgrade my case to EB1? Yes, that is technically possible, but it's not always successful. And the reason I say that is there has to be a qualifying relationship between the company in the U.S. and the company you work for outside the U.S. And you have to work outside the U.S. in a managerial or executive capacity for 1 year. That manager or executive position, just because it's called a manager, for example, doesn't necessarily mean USCIS agrees that it's a manager. Manager has a very specific definition. Executive has a very specific definition. So you may go outside the U.S. and work for a year in a position that you think is managerial because it's called a manager position, and USCIS may disagree, and then you can't get the L1A. But assuming you are able to get the L1A and you come back to the U.S. and your company is offering a manager or executive position here in the U.S., they can file an I-140 for you in EB1C category. Now be aware that yes, your priority date would be current based on your old I-140 approval, but the processing time for that EB1C I-140 is at least 1 year, if not longer. So you're just and if you decide to file another 485 along with that, they can't adjudicate that until that I-140 gets approved, and there's no premium processing for EB1C category. So it may not work out after you've ended up staying outside the U.S. for an entire year.
Krishna Mohan Reddy from Facebook has, I'm interfiling from EB3 to EB2. EB3 I-140 is not approved. If I get a green card in EB2, what happens to my GC if EB3 I-140 gets denied? Good question. I don't know. They may revoke your green card. That's the reason why we at our office do not file interfile until the EB3 I-140 is approved, because the fundamental basis for the 485 that you filed in October of 2020 or November of 2020 is the EB3. If that gets denied, the foundation is gone. So that's a big danger that you'll be doing. We strongly recommend to get the I-140 approved. Is it illegal to interfile? No, it's not illegal, but it's not a good strategy.
Rango says, can my work days overlap with my current employer and a new employer for a few days when I'm transitioning and changing the job? How many days is okay? Technically, no. If you file an H-1B transfer, you either stay working for your old company or you start working for the new company. A transfer does not allow you to work for 2 companies at the same time. If that's something that you want to do, the transfer instead would be filed as concurrent employment to allow you to work for 2 companies at the same time, and then later it can be amended to be a regular transfer if you stop working for the old employer.
Questions that are coming on misrepresentation. You should contact a lawyer when any allegation of misrepresentation is made immediately. We would recommend people to be very careful when they're filling the forms, when they're hiring people. We get so many inquiries. Oh, I filed my F1 visa. I used a broker to manage, to show the finances, and I got my F1 denied. And now I applied for the H4 visa, and because I used that broker, they hit me with a misrepresentation. This happens very frequently, guys. If you are allowing other people to submit the documents, you don't know what's in there, you will be completely liable for it. People will say, I didn't know that. Not knowing law is not an excuse. That is one of the first thing that we learn in the law school is you will not be excused. Ooh, I didn't know the law. That is not an excuse. So be careful when you are hiring anybody. If they are using any documents of their own, not your documents, you will be hit with misrepresentation. So be careful on those things though.
Vibob asks, how long is it taking for AOS E80 renewal from the Texas Service Center? The most recent one that I recall seeing approved took about 6 months. It was filed last August and got approved this week.
PERM is filed in December 2021. What is the processing time? The processing time is about 6 to 8 months right now. Is that correct? Yeah. Labor, permanently, yeah. 6 to 8 months right now.
Pavan wants to know, how many days does it take USCIS to update KCC, the Kentucky Consular Center, which is the PIM system? Once an H-1B transfer is approved, I want to travel for my stamping and make sure that PIMS is updated. Can I contact KCC to verify that my case has been updated? There's no way to contact them. They don't allow that. The only thing that can be done is to make sure that your transfer gets filed with a duplicate copy and a request that that duplicate copy be uploaded in the PIM system. I would say at least 10 days to get it uploaded there, but I don't have any specifics on that. So yeah, it can be a risk to go for stamping so quickly right after an approval is issued.
Leah Lisbon from Facebook has this question. I got a job from a healthcare company for a product manager role. Will I qualify expediting EAD based on the healthcare company? Leah, it's not just healthcare company. Your job should be in the healthcare. So you have to, if your product manager role is related to the healthcare, where you are benefiting the patients though. So when you, if you're expediting though, explain how this new role is going to help the patients get better. That would be more ideal. Not just say that I'm working with this good healthcare company, let's say Memorial Hermann healthcare company, so give it to me. No, explain it how your job role is helping the patients. That linking is very important. Not just that you are working with, not just the offer with the healthcare company.
Ronnie says, I'm in India holding an H-4 visa that's expiring in March. Is it okay to travel to the US in March? My wife has the H-1B approved and that is valid till 2024. Yes, that visa does remain valid all the way up until the very last day before it expires. When you're coming in, you can explain that carry your wife's H-1B approval notice showing that it's been extended beyond 2024. They may give you your I-94 till 2024, but if they don't, plan on filing the I-539 application as soon as you come in so that you can get that filed on time. Question
from Prabhu from Facebook. The address change, is it mandatory of getting the GC? There are some rules that are there that they don't enforce though. I recommend people filing an AR11 with address change. But here is one thing that I tell people, guys. If you are getting an email, if you're getting a call from somebody that you did not updated your address and now they want to pay you the money, that is 99.9, I would 100% fraudulent. I mean, USCIS does not ask money, guys, if you don't file the AR11 and update it, okay? We see a lot of these fraudulent agencies from India sending this AR11 saying that you didn't file it, and they will pretend as if that it's coming from immigration. Be watchful. According to our knowledge, we have not seen a single case where the USCIS have contacted and especially asked money if you did not file the AR11 or change of address. No, that USCIS doesn't do it. So be careful on those fraudulent emails people are getting.
Bharat has a premium processing request that was accepted at the Texas Service Center, but through FOIA came to know that his original ETA 9089, that's the PERM, is still at the National Record Center. Does this cause a delay in the premium processing? It's possible, but I would say most of the time when they do actually accept the premium processing and cash that filing fee check, they actually have the record available, and that's why they're accepting it. So we do see most of our premiums for the I-140s filed without the original labor. Once the premium is accepted, it is adjudicated in the 15 days.
Prashanti has a follow-up question that the 13-year-old got the index fingerprint taken. Yeah, that's right, that's fine, but still, if it's not updated, you should not be worried. He's fine, I don't see any problem in it.
Ashish says, my OPT EAD is expiring in August. filed the I-140, 485, 765, and I-131 concurrently last May with the Texas Service Center and wants to know if my GC-EAD doesn't get adjudicated by August, is there any other way I can stay in the U.S. and work? Well, the pending 485 does allow you to stay in the U.S. You can do that even after your OPT expires. The problem is you can't work until you get the GC-EAD, unless you get maybe sponsored for an H-1B in the meantime and get that approved to take effect in October with a change of status and get the cap gap and everything that goes with an H-1B.
Put you from Facebook as this question, do I need to carry the green card every time I go out? When you say go out, I mean to say if you're going outside the country, definitely yes. But if you're traveling within United States, if you're just going out having a dinner, do you carry the green card though? I personally, when I was a green card holder, no, I never carried my green card like that. I just kept it at home. The only time that we strongly recommend that you carry the green card is especially when you're going to the border towns. I can tell you some of the border towns in Texas, Harlingen, McAllen, South Padre Island. Those are the things definitely I used to carry the green card along with me because they sometimes check those things too. Any of the border towns very near, they're almost in Mexico, but they're not, I would carry. But otherwise, if I'm just traveling, if I'm a green card holder, I'm traveling from Houston to Dallas, I will not keep the GC with me on my pocket at all the times. I will not. That's my opinion. You can analyze and do what you want to.
Noor says, I think my 485 receipt came from the Nebraska Service Center based on my receipt number. What's the difference between the application received by a lockbox and a service center? So the lockbox doesn't actually receive the application. You may have filed it at a lockbox, but it's literally just a mailbox. They pick up the mail from there and then they transfer it to the actual service center for the receipting process and the actual adjudication process. So you may have filed at a lockbox, but then it gets forwarded to the Nebraska Service Center. That's why your receipt number starts with LIN, for example.
Preeti, her program got postponed after she entered the United States. Will it affect the F1 status? Ooh. How long was it postponed? Was it postponed 10 days? Was it postponed the entire semester? That definitely is an issue. If it's postponed for 10 or 15 days, that's fine. If it's postponed for the entire semester, you may have to contact a lawyer.
We've gotten a number of questions on the EID Premium Processing rule, and the same for the H4 and L2 Premium Processing that was supposed to be implemented. This was authorized by Congress in the Emergency Stopgap bill that they passed to help USCIS with its funding problems, but then it's just been sitting there. So we do know that USCIS has created the regulation to implement it, given it to the OMB, and now nothing is happening. So we don't know how quickly that will actually be implemented. These regulations that go to the OMB, sometimes they get cleared in 30 days through the OMB and then published. Sometimes it can take months or even years for that process to go through.
Tripti has this question about the healthcare professional green cards. Anything is going on, Emily? At this point of time, nothing concrete is going on. There are things that are circulating. But a lot of times, I see, Emily, is that they're just trying to appease their voters rather than actually passing any legislation. They just put it out there as if that, okay, now I put it out for healthcare, so please vote for me. But they don't actually, they know that that bill can't go through. Right. Is there any concrete bill for the healthcare workers right now going on?
Not that I'm aware of.
Yeah, I mean, people will say there are a lot of bills that are pending, guys. We are going to discuss only the serious bills that are going to come, serious things that are going to have a prospect of passing through. There are about 150 bills that are pending related to immigration in the Senate and the House combined. We can't discuss about all those things. Most of them are not going to go anywhere. They're just only because they want to get their voters vote for them. They just present it. But not to go anywhere. So definitely anything which is serious, which may affect you, we will discuss more. But at this point of time, we don't see any of those things. In fact, our last week presentation was one thing, bill dead, the bill is dead before it came on the floor. That's the reason why we didn't want to have a serious follow-up on that from you, because you will be wasting your time. It's not going anywhere. But definitely there are things this administration can do while the Congress is dead. The Congress doesn't do anything in the United States. The Congress, in our sense, is the Parliament in the United States. It really doesn't do anything.
VK says, in the DS-160, it asks the question, have you had an immigration petition filed? Should we answer yes or no if only the I-140 is approved but no 485 has been filed? So it's asking, has an immigrant petition ever been filed on your behalf? An I-140 petition is an immigrant petition, and so is an I-130 petition on the family-based side. So if either an I-130 or an I-140 has ever been filed on your behalf, you have to answer that yes.
Nicola has this question. I want to switch from H1B to I-485 EAD. Yeah, go for it. Can you please explain what are the steps needed? Just give the EAD card to your employer. That's it. There's nothing else is needed for you to shift. No filing fees, nothing.
Rohan says, my employer says he started my I-140 process and that it's in the wage determination stage. Is there any way I can check that if I want to track it? So I'm assuming you've actually started the PERM process, which is the step before the I-140. And the prevailing wage is usually the first step for that. Once it's submitted, a case number is generated. So you can ask your employer to provide you a copy of that prevailing wage request, or ask him for the case number that's associated with it. They're not required to provide it to you, so they may not. But if they do, you can track it on the DOL's website by entering that prevailing wage number, and it will let you know if it's what the status is.
My receipt notice starts with MSC. I live in Texas. Which service center I'm getting processed? Fingerprints are done 20 days back, and EB2 priority date is correct. What happens next? Well, good news is that you are in National Benefit Center, so which is good news. Unless they transfer it to any other service center or to the local office, it should be adjudicated to the National Benefit Center. And you are in the best service center that can be. Many people pray for moving their file to National Benefit Center, but in your case, you are in. Just because you live in Texas doesn't mean that your case will be processed by Texas Service Center. It could be processed by National Benefit Center. It could be processed by Nebraska Service Center. There is a possibility that they may transfer it to local Texas office for you to be interviewed. But at this point of time, it looks that you're in a good shape. And since your fingerprints are done, you have a good chance of getting approved.
Cyram says, can I travel outside the U.S. when an H-1B transfer is pending with USCIS? And can I re-enter with my existing visa stamp? So technically, yes, but I usually recommend people to either travel and come back and then file the transfer, or get the transfer approved and then travel and come back. And the reason for that is when you travel while the transfer is pending, you would come back. If you're no longer with the first employer, you'll show your receipt notice for the extension, for the transfer, and your old visa stamp. USCIS will only give you the I-94 valid to the date on your visa stamp, not what you've been requested in that transfer. And then your I-94 number is going to change when you come back in, and your H-1B approval of the transfer will come with your old I-94 number. Creates a mismatch there. So for those reasons, it's much easier just to travel first and then file the transfer, or get the transfer approved, upgrade to premium processing if it's pending, and then travel after it's approved.
I'm on H1B. If I present GCEAD, does it mean that I have moved to EAD for the driving license extension? No, you are not moving to EAD. You are still on H1B. That is only, you're not working on EAD, so you are not considered to be married to the EAD, even though you use the EAD for the driving license extension.
Emmanuel says, USCIS received the response to my RFE for a 485 180 days ago. Is it a good time to file a mandamus? Mandamus can be tough for a 485, and the reason for that is the law, the statute that created the ability to adjust status in the U.S. basically says it's up to the discretion of the Attorney General or USCIS or DHS. Anytime something is discretionary, a court is going to be very hesitant to tell USCIS you have to adjudicate this within a certain time frame. So for that reason, courts often dismiss lawsuits that are filed to try to speed up a 485 that's been pending for a long time.
Question related to visa bulletin from Natural Yogi. Visa bulletin is not out yet. Any update? No update on it. Yeah, I'm surprised. Today is February 15th and still no visa bulletin. There are some times that we issued visa bulletin in 25th of the month too. Previously, they used to issue anywhere between 8th and 12th, but nowadays we are seeing a lot of variations anywhere between 10th to 25th. So maybe we should be expecting by end of this week, I'm expecting the visa bulletin to be out. And a lot of speculations whether EB2 will move forward. Yeah, I mean, there is a chance for EB2 moving forward, but we yet don't know whether USCIS is going to use the filing chart or they're going to go with the final action date. So we'll come to know very soon. There are a lot of things going around. The USCIS administration is definitely contemplating and adjudicating many cases. So we have to see how the movement will go on this March though, and whether USCIS will accept the filing dates. Now, all these things are projections. Don't count on me. I've gone so many times wrong. There's a chance that I'll go wrong again.
Smith says, I applied for the H4 EAD in September, still under process, and I have the receipt. I'm now filing for the H4 extension, and I'd like to apply for the EAD along with it. Should I file for new EAD or renewal? Honestly, I don't think it matters. I would consider it a renewal because at some point you're likely to get the first EAD before they approve the second EAD. But those little boxes for new and renewed, I don't think it really relates to anything.
Sumit Kumar, is it mandatory to have a job at all time on H4 EAD? Absolutely not. On H4 EAD, you can be flipping a burger, you can be a Microsoft CEO, you can be a lawyer like me, or you can sit at home and do nothing.
Vijay says, has the PERM process become tougher based on the new laws published based on the Facebook case? Well, first, there are no new laws based on the Facebook case. Nothing has changed in the process. DOL basically said this is what we're deciding in the Facebook case. They didn't change any laws related to that. So based on that, no, the process has not changed, has not become any tougher, knock on wood. Hopefully that stays the same. But that case was based on the facts of that specific case. The concept behind it, companies do need to take into consideration when they're deciding how they're recruiting under the PERM process. But beyond that, the actual processing of the applications, I've not noticed a difference yet.
People are asking questions with regards to the PERM processing. Once the prevailing wage has been approved, how long it takes to file the PERM and how long it takes for the PERM to be approved. There are different processes. While the prevailing wage is pending, did the company started the recruitment process? If they already did the recruitment process though, they may file a PERM application within 15 days after the prevailing wage has been approved. If they have not started the recruitment process though, it may take a long time for them to file because they need to then advertise in the newspaper. They need to do the posting in the State Workforce Commission, and they have to do the recruitment. Once they get the resumes, there is a time period after the advertisements close. You have to wait 30 days and then do the recruitment process and interview any of the people who are eligible, marginally eligible for the application, and then they have to submit the PERM application. So the process may take anywhere between 2 months to 4 months, typically, to file the PERM once the prevailing wage has been approved. This is only if they have not started the recruitment process though. If they have already started the recruitment process and have already completed, also ready to complete, they could file it in 15 days after the prevailing wage is done. So once the PERM application has been filed with the Labor Department, it may take anywhere between 6 months to 8 months for the PERM to be approved. I'm speaking about 95% of the cases will get approved will get adjudicated within 6 to 8 months.
All right, well, I think we're out of time for today. Thank you so much for joining us. We'll be back next Tuesday at 5 o'clock Central Time. again, with the updates and answering your questions. You can always subscribe to our newsletter at rnlawgroup.com or join one of our daily conference calls. And you can take a look at immigrationgirl.com for updates as well.
Thank you very much.